So we finished section 25.1, that is called pre-grant opposition. Now we move to post-grant oppositions. Okay. So similarly, here also we see what are the criteria. So section 25A, post-grant oppositions. But what we see here, who can file application? Any person interested. Now here the question comes, any person interested now. For pre-grant opposition, it was any person. Okay. But for post-grant, it is any person interested. So you can get a question. You can get a question in exam, multiple choice question. Pre-grant opposition can be filed by government, any person, or few other things. So A and B both are correct. It can be filed by government or any person. If it says post-grant opposition can be filed by any person, government, person interested, none of the above. So your answer should be person interested. Okay. Or they may twist. They may twist the question. They say pre-grant, post-grant opposition can be filed by a person not engaged in promoting research in the same invention. A person engaged and promoting research in the same invention. So your answer should be a person engaged or promoting research in the same invention. Okay. So please be careful. So post-grant opposition can be filed by only any person interested, not anyone. I cannot go and file a post-grant, a patent published on say for production of a catalyst from this blah blah this, and I am a no person. I'm no person. I'm not working on those catalysts. I'm a patent agent. I'm practicing some other area. I cannot go and file a post-grant oppositions. Means something is published by Reliance, a petrochemical company, similar field of area, means another petrochemical company can only oppose that application because they are from the same research area, same division. A patent published based on chemistry, a biologist cannot go and file post-grant application. Why they should bother about this? Because they are not engaged in promoting research in the same invention. Okay, so that is a question. When to file? Okay, when you can file post-grant application? Before expiry of 12 months. From which date? From the published date of grant. Okay, section 45 covers date of patent. Okay, you can read more on section 45. So from the date of grant, section 45, the patent is written. This is the date of grant of patent. So from that date, you have 12 months time period to go for post-grant opposition. Okay, they do not do. And how to oppose? So pre-grant opposition was by way of representations. Okay, that should be clear. Pre-grant opposition is by way of representations. So a question maybe is asked in paper 1 that pre-grant opposition is by giving notice or by way of representation. So you must select by way of representation. The question is post-grant opposition is by way of representation, by way of giving notice of oppositions. So correct answer is by giving notice of opposition to controller. So it is a notice of opposition to controller. Which form? It is 7, form 7. Pre-grant is 7A, post-grant is 7, form 7 only. How much fees? 2,400 for nature or a startup or small, and 12,000 for others. Okay, so this is a category. Which rule? If you refer the rule, this is rule 55A, where all details are mentioned. And what is the procedure for opposition? What are the steps happen once I apply for the post-grant oppositions? So these are the process. Okay, so according to rule 56.1, constitution of opposition board with 3 members, with one of them as chairman. So in paper 2, you may get a question, what is the procedure of post-grant opposition? So they are not going to ask this question directly. What is the procedure for post-grant opposition? They may bundle this question with some other scenario. A person has come who is from the chemical field and the same invention area, a patent had recently been granted, and he wants to file the post kind of positions, or the question will not say he want to file post kind of position. Question will say, as a patent agent, how can you help, and please explain also the process, what are the procedures takes place. Okay, so then you need to write everything that according to section 25(2), post kind of opposition can you file by any person interested, and because you are in the same field, you are eligible to file post kind of opposition. Sometimes a 5 marks question can be asked saying that a person working on genome sequencing comes to saying that a Reliance has filed a patent on cobalt catalyst and he want to oppose this. Then you don't need to write all the steps given here. You just need to say, according to section 25(2), post kind of opposition can only be filed by person interested, and according to section 2(t), person interested is a person engaged or promoting research in the same invention. But because you are from a person from genome sequencing, you cannot file a post kind of opposition for cobalt catalyst used in the petrochemical industry. That's all. That is your answer. If you don't write, you write whole history here as it is given. It can be filed by any person interested. These form 7, form these and procedures, you will get 0 marks, because according to scenario given, this person is from the gene sequencing field, and the patent that he want to oppose is from cobalt catalyst used in petrochemical industry. He has no connection. He doesn't fall in the criteria of person interested, so he cannot file the post kind of position. So these are tricky question. So because I'm not discussing here the question paper exactly, but I'm giving you what kind of question could be asked, or as I remember some questions that were asked, I'm giving you. So please try to understand, and if you want to make notes or something like this, please continue to do this. This recording is available for you to watch anytime. I will upload this also. So, and so what it says, what is the procedure? And please remember this procedure 56 to 63, because this is the procedures for any kind of notice of oppositions. Notice of oppositions is filed for post oppositions, and also for any other notices will come in the later sections, that anytime you want to oppose any notification published by the controller and you want to understand what is the procedures. So this is the same procedure, rule 56 to 63. This is the same procedure. So I'm going to discuss this procedure only once, and thereafter we'll just refer. Whenever I say procedures, we'll just refer rule 56 to 63. Okay. So what it says, rule 56, that constitution of opposition board with 3 members, with one of them a chairman. So there will be 3 members, and out of 3, one will be said that he is a chairman. Okay. And who can be member? So examiners appointed under section 73(2) are eligible for board members of opposition. So in section 73(2), it is given that examiners are appointed, and government can appoint any number of examiners. Only those examiners as appointed by central governments are eligible to become the board members for the opposition. But there is condition: examiner who dealt with application of patent are not eligible for the member of opposition board. So when we file an application, then controller gives an examiner. That examiner will examine the patent. He will do the patent search and make the reports. That a specific examiner will not be considered in the board of the opposition. Okay. Opposition will examine documents filed under rule 57 to 60. So these are the 57 to 60. Okay. These are the rules. We will read again. So opposition will examine all the documents that are filed, and they will give the joint recommendation within 3 months from the date of forwarding documents to them. Okay. So when they receive the documents, so they take 3 months time period, and they will give their joint recommendation as a complete member, as a 3 member. They will give their joint recommendation. Meaning that I may agree to some points, my other examiner may agree to some other points, and the other third person may agree to some other points. So we cannot say I feel like this, he feel like this, and he feel like that, and the controller has to decide what is the final. No, jointly they need to give one recommendation, what they want to say about this. Okay, and what are documents? Rule 57, filing of the written opposition with evidences. So first document is the any person interested will file a opposition, means he will file form 7, pay the fees as applicable, and in that form 7 he will also give evidences, means all the evidences, all the prior arts and everything he will give, and it is given in duplicates, and a copy is sent to patentee. So a copy also sent to patentee. So patentee comes to know that post grant opposition has happened, and you receive a notice. And so these are the documents, means what are the prior arts, this patent number, this publication number, everything you patent also gets. Rule 58, patentee gives reply with evidence within 2 months from date of receipt of written statement. Okay.
Prem, this copy sent to patentee, who will be sending this to the patentee? Is patent office or the applicant has to send?
Okay.
Sorry, that opponent.
Okay, let me open rule 57. Opponent shall send a written statement in duplicate, setting out the nature of the opponent's interest and fact upon which he bases his case and relief which he seeks. Okay, and evidence, if any, along with the notice of opposition, and shall deliver to the patentee a copy of a statement and evidence, if any. So it is the duty of the opponent to deliver the copy to the patentee.
Okay.
Okay. So as I said, in case of any doubts, any question, we'll read the exact statements. Okay. So rule 59. Okay, 58. Patentee gives reply with evidence within 2 months from date of receipt of written statement. So patentee will give reply, means patentee is not going to give reply to me. He will give reply to the controller. And if patentee does not give reply within 2 months, patent is revoked. Simply revoked. Okay. If he fails the deadline of 2 months, patent is revoked. Okay. So he must give reply within 2 months. Therefore, all the attorneys who are working, and if you get the notice and he is on vacations, and when he comes back, he has lots of emails to read, and he forgets what is there, then he misses the great opportunity, right? The patent is revoked. 9. The opponent can send reply limited to patentee's evidence within 1 month from the date of reply from patentee, and a copy is sent to patentee. Okay. So opponent means the person patentee, the person who owns the patent, he gives the reply within 2 months, and he gives some evidences. Okay. So you give evidences, he also gives evidences. Now I cannot add any further evidence now. Okay. Here my role is just limited to the evidence that he has submitted. I need to submit within 1 month. Okay. And rule 6 says no further evidence, either party can pray for hearing. Now rule 6 says no further evidence. So once when I oppose, I give some evidences. So therefore, while giving the evidence, we should be very much careful which to give, how much to give, and how to give, because we not get many chances. And once we get the reply from the patentee, again we have a chance to give evidence, reply, not any further evidence, reply, or only based on the evidence that is provided. And thereafter there is no, but you can pray for hearing. Okay, you can ask that we want to go for hearing. Okay, you can ask that I want to go for hearing. So you are not satisfied with the reply, then you can ask for hearing. And then what happens? Rule 61, all authenticated copies of evidence to be sent in duplicate attested translation in English needed if language of evidence other than English. So you need to give, if the language is not English, it is other language. For example, there was one case where some evidence of Sanskrit language are used. Means mostly in case of if the evidence is for traditional knowledge. So if it is in Canada, if Karnataka Kannada language, or if it is Assamese language, or Hindi language, or Sanskrit language, or any other languages could be there. So, and then we need to translate that English and give the attested translation. We need to give that as evidence. Okay. Rule 62, hearing happens. So hearing will start, and control will give 10 days notice. So he will give a date of 10 days. So he will give 10 days time period to join. And if either party wants to attend the hearing, okay, control will give that, yes, I am ready for hearing. You pray for hearing, and control says the hearing. Hearing will happen only, you can attend the hearing if you pay the fee. So what is the fee? 1,500 for natural person and 7,500 for others to be paid. We need to pay the fee to attend the hearing, and control will not hear if fee is not paid along with the notice. Okay. So when you give the notice of hearing, that time only the fee is paid. Okay. If anyone wants to bring new documents not submitted before, okay, so suppose you feel that because according to rule 60 you can't sell any further documents, but you feel that now there are some more documents are there that I need to submit, then before he needs to inform other party not less than 5 days with details. So we need to give him time, and then if that time after hearing date is fixed, you can give documents, and control will notify both party of a decision based on opposition board recommendation or hearing process, and then control will give his recommendation. Rule 63, patentee may withdraw the patent after notice of opposition and after notifying controller. So a patentee can withdraw the patent if he sees the notice of opposition. So he has the right to withdraw the patent. He may say that, okay, I agree with the whatever he said, and he don't want to go with all those processes, and then he can simply withdraw the patent, and he can notify the controller that I'm going to withdraw my patent. So this is the process and all details given here. Next, we are going to go to read what are the grants of post-grant opposition. So good part is that all the grants are almost similar. Pre-grant grounds of oppositions and post-grant grounds of oppositions are almost similar. So if you read like this, wrongful obtainment, presence of prior, okay, then second patent, as you discussed, that patent published after the prior date but having a earlier prior date, evidence of use, okay, but we need to see that that evidence is not for legitimate trial or experimentation purpose. Obviousness, lack of inventory step, not invention, not patentable, insufficient complete specification, failure to comply with section 8, convention application not filed within 12 months, wrongly mentioned geographical source, okay, traditional knowledge. So you see all these conditions are similar as in the pre-grant operations and post-grant operations. Okay, so both the conditions are same. Okay, so you can see that both are same. Here I have written grounds for pre-grant operation. It is actually grounds of post-grant operation because they are same. I pasted the same, so you can remember that both conditions are same. So if you remember once, you remember for all time. One criteria here it is given here that what it says, section 25(5) says that section 25(2)(d) public use, okay, public use, and section 25(e) inventory step over what is used in India, personal use, secret trial or secret use is not considered. So this criteria is not there for pre-grant opposition. This is only available for post-grant opposition. So post-grant says that if I can prove that the public use was my personal use or it was secret trial, so for example, I prepared a bulletproof jacket and I was wearing inside my shirts. So other person cannot see my shirts. I'm wearing that, or it means secretly used, and somehow you got some evidence and then you produce. So those will not be considered. 25D, evidence of public use or publicly known. So this will not be considered. So in case of pre-grant opposition, reasonable trial and experimentation is considered. But here for the post-grant oppositions, personal use is also exempted. Means pre-grant opposition, it has to fall regional trial and experimentation only. But in case of post-grant opposition, personal use is also included, and second trial and second use is also included. So those are excluded. Okay, and if patent is amended after decision after control of notice application. So 25(6) says that patent is amended after the controller notice application. So we read 25(6). In case the controller issues an order under subsection 4, okay, that the patent shall be maintained subject to amendment of the specification or any other document, the patent shall stand amended accordingly. So rule 25(6) says that after the opposition board is formed and everything is decided, so if controller asks for the amendment, so patent remains as an amended patent only. So all amendments are included, means amendment of descriptions, amendment of claim, whatever is there, so that need to be incorporated. Any question till now? So with this we concluded this pre-grant and post-grant positions. Any question now?
No,
Any doubt?
no.
Okay. So I will just